Welcome back to the 4BC Drive Show. It's time now for the legal lowdown with our friends at Attwood Marshall Lawyers. Today we're covering the topic of suspicious wills after a fascinating case played out in the Supreme Court in New South Wales. It starts with a 90-year-old woman, a $3 million estate and a will that she signed late in life. But this case raises questions about what she knew when she signed the document. While the solicitor who prepared the will and the willmate never actually spoke, I just wonder how this happens. And what happens to a will when the court isn't satisfied that this is the person's true final wish? Duncan MacDougall, Estate Litigation Senior Associate at Attwood Marshall, joins us now. Duncan, thank you so much for joining us.
Thanks for having me again.
Just if you can just give us a quick rundown of what's happened here. A 90-year-old woman has a $3 million estate and she has a will, and then she changes it at the last minute.
So in this one, you've got poor Wilma in a process of getting her estate planning looked at. However, she's got some so-called influence by her late de facto partner's son, who's kind of taken control of her affairs, her enduring power of attorney, guardianship, and the like. He's gone and said to a solicitor that he's previously dealt with, hey, listen, Wilma's needing some new affairs in order. This is what she's saying. This is what's happening. Unfortunately, with this one is that on the evidence, Wilma says, hey, Jeff, I'm going to leave you my house. However, what the will ended up saying is, Jeff, I'm going to leave you everything. And further to that is that in this case, the solicitor didn't actually meet with Wilma, didn't actually properly make sure she knew and understood what the will actually said.
Right, or if she had capacity or
exactly.
It was just this de facto son.
Yeah, exactly.
Okay, so given that woman was 90 and that she had memory difficulties, it would be safe to assume that this came down to that capacity, that testamentary capacity. What did the court find out about her condition when she signed the will, and did that affect the outcome?
Yeah, so in this case, the court actually determined that she indeed had capacity. She did actually have that what's called testamentary capacity, that she has the marbles to know what she's wanting to do. But what's actually on paper here, did she actually know and approve the contents of that will itself? So the will was actually executed not in front of the solicitor, it was executed in the care home. There's on the evidence it was apparently read out to her as well. But reading out some document that you're going to put a signature to is one thing, but actually knowing and understand the practical and legal effect of this document and understanding, okay, I'm leaving you a property here versus I'm going to leave you my entire estate. There's a lot of things there that the court viewed as so-called dodgy.
Right.
And of course, that will was made invalid, and her previous will that benefited charities and some friends ultimately prevailed. So somebody who was expecting a $3 million estate ultimately ended up back with the beneficiaries under the previous will.
As per her wishes.
Per her wish.
Because there are cases where a will can be contested by someone who shows capacity for, needing money or whatever it might be as part of that. I guess, so how can a solicitor preparing a will and the person leaving a will not speak to one another? Sure, you have to.
You have to. It's a poor form on their part that this actually occurred. But this is what, in terms of people trying to do these things themselves as well, it's important that you get a qualified solicitor who knows what they're doing, knows the questions to ask, Hey, Wilma, do you understand the practical effect of this happening? Do you understand what's in your estate? Can you list your assets? Do you know who can have a claim against your estate? All these sorts of things a solicitor will go through. And part of this whole estate planning is to make sure that her intentions are carried out, for one, under a document, but it's making sure there's a good paper trail there as well, so that if things do go pear-shaped down the track, you can rely on this will file to show that there's evidence that these proper inquiries were taking place.
Well, you are qualified. If you've got a question that you would like to ask Duncan, he's a State Litigation Senior Associate, you can text through 0499 880 882 if you just need some general advice, or you can call us as well, 133 882. I guess the other red flag in this case is that the will was vastly different from the previous ones that she had. Surely when something like this comes across your desk, that is a red flag and it's immediately suspicious.
Well, it's suspicious in the fact it's coming from somebody who's ultimately going to benefit from the estate. I mean, it's common that sometimes relationships change, circumstances change, and some people might do a complete 180 and change their intentions, and they're entitled to that. So even at 90 years old, you're entitled to make any sort of changes you're wanting to make, but you kind of have to look at the whole picture. What are the reasons? What are the what kind of influence is this based on? Do they actually understand what they're actually doing here by changing these terms? Who's this actually coming from?
Right.
All these red flags that don't naturally happen. Sudden changes as well. If there's a long-standing history of certain people benefiting, then all of a sudden there's a flip of a change. Where is it coming from? And this is where claims start to arise.
I guess the other thing is, you are perfectly entitled to change your mind about
Absolutely.
who inherits what. But what should, I guess, solicitors or family or will makers be doing if they wish to make drastic changes?
Yeah, so by all means, that's fine. That somebody can assist. For instance, in this case, an elderly woman in her 90s may need some assistance in getting to a solicitor, getting those wishes on paper. Nothing wrong with those people facilitating that as well, but bringing them to appointment, arranging the phone calls, that sort of thing. But at the end of the day, it's going to need a one-on-one. Those instructions have to come directly from the will maker.
Yeah.
That person shouldn't even be in the room when those instructions are given. Get a bit of an understanding of your assets, your liabilities, have an idea about the risks to your estate. Make sure everything's documented properly.
Sue from Eden's Landing has called through with a quick question about her will. Hello, Sue.
Hello. Just wanted to ask, if I have a will made out and it's left to my 4 sisters and brothers and one of them passes, do I need to have that name removed from the will, or
I would
is it
say
okay to leave?
I mean, it depends on your circumstances. I say generally every 3 to 5 years is a good benchmark. I mean, if that beneficiary is no longer around, then obviously then there's no distribution to take place to them. But it's important that somebody at least review the terms of that document just to make sure the T's are crossed, the I's are dotted, because you never know if there's some sort of distribution wording in there that needs to change, given that this person is no longer around. Unfortunately, yeah, it just depends, Sue.
Okay. All right. Thank you very much.
No worries. I hope that has helped too. Duncan, thank you so much, as always, for joining us, the Legal Lowdown. We will see you again next week.